Yes.
Live one or maybe one.
Yes. What this matter? Where are
No one
these-
is there.
Both the accused persons are present.
Yes, Your Honor.
Accused Plai Phawa and Kanim Dobon present along with defense counsel Srimati M. Suchia. Additional prosecutor Additional prosecutor T. Lambang present. No report on the summons issued to the witness. Prosecution is at liberty to take fresh step, prefix for evidence. Yes.
Break the line.
This also no one is there.
Accused Brick Talang present. Defense counsel. Anybody representing the accused? Defense counsel absent without any steps. Additional prosecutor T. Lambang present. No report on the summons issued to the witness. Prosecution to take fresh step, prefix for evidence.
One hay per cut the tongue.
One witness is there.
One time hard.
Yes.
Your Honor, this court or white order on 411, Your Honor, please call for the original medical report from Negrim, Your Honor, and the report is here.
Where's the original medical report?
That one.
So you can exhibit it.
Yes, sir.
You can take it on record.
Okay.
Where's the order, last order? Pursuant to the order, pursuant to the summon issued, no, pursuant to the summon issued by this court under section 91 of the CRPC. Who is the person who has produced? Who is she?
What?
I'm a medical record officer from Negrim's Hospital.
Your name, please.
Ms. Jaintia.
Your identification?
ID?
Yes. Where is the summon?
Someone is there.
Where?
In the report.
Who prepared this summon? Please come in. This is not the summon for under section 91. This is summon to witness. Summon under section 91 is different. This is summon to witness. Pursuant to check the CRPC. Pursuant to the summon issued by this court under section 91 of the CRPC, directing the, whom did we direct?
Medical superintendent.
Directing the superintendent of Nirgims to produce the medical certificate, original medical certificate of the victim. Name?
Yeah. He is a witness, Your Honor.
Huh?
He's a witness, sir.
He's also a victim
Yes, sir.
of the victim slash witness. Miki Rato.
Kilato.
The original medical report of the victim is produced before this court by medical record officer Srimati Miss Milsilinda Rentathiang. Where is the original record? Where is the original medical report which you are looking for?
The original stairs, sir.
Which one? Flag it. The original medical record is produced before this court, along with the in the relevant file. What is this IP number means?
Inpatient number.
And what is the CR number means?
Case record number.
What is this? What do you write?
The original medical report of the victim is produced before this court by the medical report officer, agreeing to retain the standard Tatyam in the relevant file.
The file number being case record number 82023/18 colon inpatient number 11668/18 neuro surgery department. So which report do you want?
I've just flagged it.
No, give one copy to the defense also.
Yes, yes, Your Honor. Will do.
You want to retain the file?
No, just a medical report. Sir.
You have any objection to this? Will admit it?
Yes. Yes.
Only this?
Yes, sir. Only this.
You are admitting it without any objection?
Yes, Your Honor, as per instruction from my.
We don't function at the instructions. Don't give that to me. What instructions? I'm bound by instructions. We don't function on instructions. The medical certificate, which is gone as paper mark 1 during trial. The original is produced before court. Good. The original and the original copy and the paper mark is same.
Compile him.
The original copy and the paper mark is same.
Our paper mark is discharge summary, Your Honor. And it is here also. Discharge summary is here.
Forget about that. Please listen to what I'm saying.
Okay.
The original paper, the photocopy has gone on record as a paper mark.
Yes, sir.
So now you had asked the original to be produced in the court. She has produced the original. Now have you compared with the original and the paper mark is same?
No, Your Honor. Understand.
And you are saying that you don't have any objection. You are conducting trial or you are just having a joke with the court? Without seeing the copy, without having the copy, you say that I don't have any objection. So what do you want to exhibit it?
I will take on record the same also, Your Honor. The
So
discharge
please
summary.
first answer the question is that paper mark used as per the my last order,
Yes, sir.
you said that the original is with the doctor
Doctor, yes, sir.
or with the hospital. and the paper mark has gone on record. Now we bring the original. The paper mark one is there on record.
It's here, yes.
Paper mark.
Yes,
It's same.
it's the same.
Paper mark.
The paper mark one and that discharge summary which has been produced.
Same.
Yes, sir.
Please have a look properly. Turn it back. Look at the signature.
Yes, Your Honor, it's the same.
Bring. Send somebody, send this boy also to make a photocopy also. Turn back. Which one do you want to exhibit?
That discharge summary on.
Which one is discharge summary?
The one with the triangle seal on the
Huh?
the one which with the triangle seal on the far right.
What about this one you have flagged?
That one also I'll take on record. That is
You have the copy of this?
I'll supply to him. Yeah.
No, not yet.
Huh?
No, we don't have the copy.
What is the last sentence?
Medical certificate which is born on paper mark one didn't try. The original is presented before this court.
You have any objection that this paper mark will bring the original and exhibit it?
No.
Paper mark one? Without any objection from the defense. What is this document?
Discharge summary. Yeah.
Where it says discharge summary? This says that the paper mark one. Oh, paper mark one. Without any objection from the prosecution, from the defense. The original of the paper mark one is taken and record and marked as exhibit. Exhibit. B exhibit. What is the last exhibit? Look at the first page in the list of exhibits. Hmm?
Exhibit 1, exhibit 2. Maybe.
Is that fair? It goes exhibit one.
It'll be exhibit 2. If I'm not mistaken, that's the record.
As exhibit 2, we are not going to change anymore. And if you find that there are discrepancies in the exhibit, we are not going to look at those documents.
Okay.
When you are summoning somebody for producing the documents, you should be very clear about the exhibits. If at all the original is produced in the court, it has to be exhibited as what number. The original medical certificate also is also produced. The original medical certificate of Miki Lato is also produced. Copy supplied to the defense. You have any objection of this being deposited, exhibited?
No.
Who is this person? Tamai Jyoti? Who is a witness? Is he a witness? This court shall examine the file before the medical report is exhibited. The case record file of the victim shall be retained by this court. It is only after examining the case record, the file shall be returned back to the superintendent Nirgams. We'll return back the file, we'll give you a certificate. We'll give you a certificate that the file is with us.
In I certificate paper, invoke a file.
We'll return you back. You'll come and collect the file, or we should send it by post?
Yes. Send by post.
We'll issue a certificate. We'll issue a certificate that the file has been retained by us, and we'll return it back after we have scrutinized the file. And if at all we are taking any original papers from the file for the purpose of trial, we will give a photocopy with a certificate that the original is with us. After the trial, if you need those certificates, original back, we can give you back. We may either compare with the original and retain the photocopy. Yes. Next.
Timothy.
Issue certificate that this file is with us. Have you paginated the file? Madam, have you paginated the file?
Yes.
Have you paginated the file? Write down how many pages are there in the file. Please paginate the file.
No, sir. Page
Please.
number?
Yes. Yes, next.
Timothy,
No, sir.
Bilon, Hyman.
Yes. Yes. Where are the other accused persons? Who is the accused present before this court today? What is this case? Who is the accused present before this court today? What about the other two accused persons?
Other one accused person here, he's not feeling well.
Well, let them be there. We'll see if we can examine today. Yes.
Dentist too.
Yes.
Your Honor, this is a case where I have prayed for dispensation of Bill 313 as the accused is very ill.
We dispose of this matter. Who is appearing for the prosecution?
Actually, it is Len Pipi.
We dispose of. Yes, next.
Hak lang thua. Don thua.
This is also 313.
313
Today, no. Prefix. Yes.
accused person are present.
We'll do it some other day. Today we are passing that order. Your case. Yes.
Dimusud. Moldison. Fe. Binia.
Dismiss it. Can I? Why do we have so many MSCT cases today?
Same accident.
7 cases.
Yes.
Who's appearing for the insurance company?
Appearing for the insurance.
All these cases arise out of the same accident.
Yes.
So, who's appearing in first case?
I'm appearing, Your Honor, for MSCT case number 1.
Yes. Is it a death case?
Sorry, Your Honor.
Is it a case of a death?
Yes, Your Honor, there are some. I'm for the claimant, Your Honor. The injured person here, Your Honor, he is a minor, Your Honor. He suffered injuries, Your Honor.
What is this matter fixed for today?
It's for hearing for application under 170.
Huh?
It's for
hearing.
deposition, Your Honor.
No, actually, we have filed the application under 170. The last date, Your Honor, it's fixed for hearing.
Yes.
File for safety.
Anyway, we'll first take this divorce matter and then after that we'll take up the matter. You filed an objection to the application filed by the insurance company
No,
under
no,
section
that is
170.
for another matter, Your Honor. Another.
In your case, the owner and driver, they have appeared.
Yes, they have filed written statements, but ex parte order has been passed against them.
So you're not claiming to take a defense of the owner and the driver under this case number 1?
I'll clarify on that because I got one judgment, Your Honor.
Forget about the judgment.
Yes, I'll take the defense.
Where have you filed any application for that?
Yes.
But she says no.
No, on other cases because they.
We are not concerned. We are in item number 1.
I'll file it.
Have you filed an application under section 170?
Application under 170, Your Honor. I've got one judgment.
What do we do with the judgment if you have not filed application? Don't speak nonsense.
I have filed. For them, I haven't
Come to
filed.
that application. You have not filed an application, you're talking about a judgment.
For the case,
Item number 1. We are in item number 1. We don't take up 10, 20 matters at the same time.
for item number 1, I haven't filed.
Say so. Are you filing application under section 170?
Yes. I filed for.
This application has been filed under MSCT number 2. But you have filed. You don't know your own case.
No, because many cases clubbing together.
So what if there are many cases? Don't take up this matter. When you are prepared, you come. What do you mean by so many cases are pending? Just because many cases are pending, we also start passing any orders because many cases are pending.
Actually, Your Honor, let me clarify. Actually, in this judgment that I have, there's
Please
no need-
don't talk about judgment. What is the occasions of the judgment? Why you refer to a judgment when you have not filed any application?
Application is not required according to this judgment, Your Honor. Application under section 170 is not required.
Then we'll strike out this section 170. They don't have the right to oppose it.
No, actually, from my side, I don't need to. I'm not required to file application under 170, Your Honor. According to this judgment, Supreme Court judgment.
They cannot object to it.
I'll withdraw the application, Your Honor, because for
The defense has got no right to file any objection.
No.
Read the operative part.
yes. When an insurer is pleaded as a party respondent
Yes.
to the claim petition, as contrast from merely being a notice merely being a noticee under section 149 clause 2 of the Act, its rights are significantly different, Your Honor. The Act does not require the claimant to implead the insurer as a party respondent. But if the claimant choose to implead the insurer as a party, not being a noticee under section 149 clause 2, the insurer can urge all grounds and not necessarily the limited grounds mentioned under section 149 clause 2, Your Honor, of the Act. If the insurer is already a respondent, having been impleaded as a party respondent, it need not seek the permission of the tribunal under section 170 of the Act to raise grounds other than those mentioned under section
Read the whole
149 plus 2.
judgment. Read the whole judgment.
This case is between United Indian Insurance Company Limited versus Sheila Datta and others. It discuss about the
We know
grounds.
this judgment.
Hmm?
Insurance company is not a necessary party.
Yes, but
Does it
if
say so?
if I'm made a respondent by the either by the court or by the claimant as a party respondent, then I'm entitled to raise all the grounds available, Your Honor. Then if I'm only made a noticee, but not a respondent, then application under 170 is required, Your Honor, according to this judgment.
Read the whole judgment.
Yes. Here it discuss about the grounds available to the insurer to contest claim petition. Distinction between his right as a noticee and his right as a party respondent, Your Honor. Insurer, if impleaded as a party respondent by claimants themselves, under section 170 of on section 170 by MACT, held can contest claim petition raising all grounds without being restricted to the grounds available under section 149 plus 2. However, when he is merely a noticee under section 149 plus 2, whether consequent to the claim petition or in suo motu proceeding initiated by MACT, he can defend claim only on the grounds mentioned under section
So
149.
you have been impleaded.
Yes,
Who impleaded you?
the claimant, Your Honor.
When did they implead you?
From the time they file a claim petition.
What is distinction between a party and a party being impleaded?
Uh,
What is the distinction between a person who is already a party and a person being impleaded?
yes. Noticee, Your Honor. Noticee, if I'm not made a party respondent, noticee it is discussed in section 149 plus 2, Your Honor, the old act. Here, a noticee, if I'm not make a respondent in the claim petition, I'm only notice was left to me, Your Honor. Then I'm a noticee in that case. Then the rights available to me is only those mentioned under section 149.
What are those rights?
Rights, see,
No, don't look at those things. What are those rights?
rights to contest only about the policy, the policy, the license, and only document.
Only the breach of policy.
Yes, breach of policy.
So if you have made a regular party, that means the owner will, even the defense of the owner you can take.
Yes, Your Honor.
No, we are not reading the judgment
About
properly.
the quantum and
No.
reduces, Your Honor.
That's not how you read judgment. This Sheila judgment, we are aware of that. You are not a necessary party. You are just a part. You are a person just to pay the compensation. Automatically, your defense is only to the point of breach of contract. And if there is no breach of contract, you start agitating the matter on merit.
According to this judgment, Your Honor.
You have not understood the judgment properly. You mean to say that you can contest on behalf of the owner and the, what happens to the owner and the driver? You'll contest on their behalf.
Yes, Your Honor. Only
You are about by virtue of being in contract with the owner. There is a contract also to represent him. In the policy is that you'll represent him in the court.
no,
Then you'll represent the owner and driver in the court.
no, Your Honor.
You'll defend for them.
No, Your Honor.
Read section 170, what it talks about. If you are impleaded as a regular defendant, what 70 talks about?
70 talks about impleading insurance in certain cases.
Yes.
Yes. Where in the course of any inquiry, the claim tribunal satisfied that there is collusion between the person making the claim and the person against whom the claim is made. or the person against whom the claim is made has failed to contest the claim, it may, for reason to record it in writing, direct the insurance who may be liable in respect of such claim shall be impleaded as a party to the proceeding, and the insurer so impleaded shall thereupon have, without prejudice to the provision contained under subsection 2 of section 150, the right to contest the claim on all or any of the grounds that are available to the person against whom the claim has been made.
That is the question is all about.
Yes.
Have you been impleaded as a regular?
Yes.
Have you been impleaded as a regular defendant in this case?
Yes, respondent. Yes. That's.
It is only after the owner and the driver, if there is an allegation of a collusion, or if the owner and the driver fails to appear and defend. In that case, you become a regular defendant. Then don't file written statement also. If you go by this judgment, you are not supposed to file written statement also.
Yes. But if I'm made, according to my understanding, if I'm made a party from the beginning, Your Honor.
If you are made a party after the owner and the defendant are found to be in collusion, if the claimant and the owner they are found to be in collusion and you are made a party. Next, if the owner fails to contest the case, then you say that because I have to pay the money, I will contest. But if the owner is contesting the case, you'll become a party. You don't need to be impleaded. What is your defense under section 149? Only breach of policy.
Yes, breach of policy.
So you've got a statutory defense.
According to my understanding.
It is only when the owner has refused to appear or the owner after appearing has failed to contest, then you say that I will become a regular defendant and I'll defend the case. To read the judgment as if you can straight away, moment you become a party, the owner and the driver becomes a non-suitor. What will the owner and driver do if you start defending them? You'll go on the merit of the case. What is your right in this case?
Right, Your Honor.
What is your right in this case? What right you are protecting?
Right.
Only the policy, isn't it?
Yes.
You can go beyond the policy. When? Only when the owner and the driver they don't. Or there is a collusion between the claimant and the owner and the driver. Is there any case for collusion?
No case. Only they fail to contest.
They fail to contest. Then now you file an application at 170 exactly for that. That you should be made a regular defendant.
Application I filed.
And madam, you
just
say that they have not filed, they serve the copy. That is exactly the situation as arises now. You become a regular defendant. You want to become a regular defendant.
Yes.
Just because you are party there, it does not mean that you are a regular defendant. Your defense is confined to statutory defense. But if they fail to contest, you say that now I should be made a regular defendant. That is 170 all about. And you can be made regular defendant only on two grounds: collusion and owner and the driver not contesting the claim. So now with this application, you want to become regular defendant.
Yes, sir.
Prior to this, even if you are a party, can anybody be said during a trial of a suit or suit for damages that no, we will not allow you to defend? Can we say so? If you are a defendant, can the court or a tribunal say that we will not allow you to defend? But in this case, you are not allowed to defend.
Yes.
You are not allowed to defend in full scale,
Yes.
only to the point of the breach of the policy. That's all. You are not a regular defendant. But if you are impleaded as a party, means you come and prove the court or establishes that look, there is a collusion between the claimant and the driver. Now I want to become a regular party. That's all right. Or you can say that look, the matters proceeding ex party, they are not contesting. I have to pay. So now I should be made a party here. I'll defend the case on merit. That is what the judgment says. Just because you are a party, it does not mean that you are a regular party. Are you not in a different footing with the owner and the driver as of now?
Yes, as of now, yes.
Can the defendants, if there are 5 defendants, can any restriction be imposed on any of the defendant that your defense will be limited? Can we do so?
Yeah, right.
In normal suit, can we say that if there are 5 defendants, can we say that no, one defendant will defend only this much, the second defendant will defend? So is there any such law? Can we do so? No, we can't do. But under the MSCT, your defense is bound. You are restricted to your defense under Section 149 to the breach of policy. But then this restriction or the embargo goes off if you file an application under Section 170 and make out the dual grounds.
What about this part, Your Honor? In this paragraph, if the insurer is already a respondent, having been impleaded as a party, respondent.
What is the distinction between a person who is already party and being impleaded as a party? When do you implead a party? 1 second.
Here,
Yes, when do you implead the party?
either by voluntarily by the claimant, Your Honor, or
Yes.
by the court under section
When do you implead? What do you mean by, what is the meaning of impleading?
implead as a party.
Read, you have CPC. Give the CPC, read order 1 rule 10, order 1 rule 1, read. Impleading means adding as somebody as a party. If you are already party there, whether you are regular party, if somebody has filed a claim petitions, you are regular party. You are made in party only for the purpose of paying the compensation, isn't it?
Yes, sir.
Are you a regular party when suppose somebody files a claim and makes an insurance company a party? Are you a regular party?
Here it discuss about difference also between the noticee and a party respondent, Your Honor.
What is the difference?
Yes. There is a difference between an insurer and a noticee under section 149 clause 2 of the Act. An insurer as a party respondent in the latter case, it can contest the claim on all grounds. And
Yes.
if in the former case, it is entitled to be made a part. In the other case, it is entitled to be made a party to deny the liability only on the grounds mentioned under section 149 clause 2.
You got it?
Yes.
Read again.
There is a difference between an insurer as a noticee
Yes.
under section 149
Yes.
of the Act
Yes.
and an insurer as a party respondent.
Yes. So you are just a noticee now. Once we give you the right to defend on all the grounds, then you become a regular offendant, a regular respondent. You are just a party as a noticee. Do you have the right to defend on merit now? Now? Give the citation of the thing. Get me the book.
Yes. Here it also talks about this matter, Your Honor, where the insurer is a party respondent, either on account of being impleaded a party by the tribunal under section 170 or being impleaded as a party respondent by the claimant in the claim petition voluntarily. Here I've been impleaded as a party by the claimant.
Yes.
Voluntarily by the
Read
claimant.
the whole thing.
It will be entitled to contest the matter by raising all grounds without being restricted to the grounds available under section 149 clause 2 of the Act.
When can you take a defense? You are very wrongly reading the judgment. When can you take the defense of the owner and the driver? When?
If I'm being made a noticee on the honor,
If you are
yes, if I'm only being made a noticee,
Yes.
then the rights available to me are only those rights mentioned under section 149 clause 2.
Yes.
If I'm being voluntarily made a party respondent, according to my understanding,
Yes.
voluntarily by the claimant, as mentioned here, I am entitled to contest on all the grounds. Your Honor.
You're very wrongly reading the judgment.
It's okay, Your Honor.
You read section 170. Why don't you understand one thing? See, what is the consequences of you becoming a regular party? What happens? Means you can take the defense of the owner and the driver, isn't it? Just look for a situation. All right, just imagine a situation. We go by what you submit. Let's, for an argument's sake, look at a situation where you have been made a party, a claim petition has been filed, you have been made a party as respondent number 4. Okay? And now respondent number 3, usually the owner, driver, you are number 3. Now we go by your argument. You say that just because I've been made a party, I can take the defense on merit, isn't it?
Yes, that's my
Otherwise, the defense on merit is only available to the owner and driver. Now, owner and drivers are appearing. One second, listen to me very carefully. Owner and drivers are appearing and contesting the case. Okay. Now, owner, driver, and you are three different entity, isn't it? Can you defend for the owner and driver when they are defending themselves?
No.
Can you do that? When
No,
the
for
owner
on
and
their
one
behalf,
second,
yeah.
please listen to me. When the owner and driver are appearing and contesting the cases on merit, can you defend them?
No.
No. So, if you read, just by virtue of you being made a party, you can defend for them. That's what you're saying, isn't it? Just because you are made a party, you can defend for them, in spite of they defending them for themselves. That will be an absurd. One. Second, if they are there not defending, different issue. Now, when they are defending on merit, you are also a party. All right. In that case, your defense will be confined to section 149. Statutory defense. You will contest the case, but your defense will be only to the point of breach of contract or the breach of policy. Now you say that if you go by what you're submitting, if you go by what we are submitting, what will happen? You know what will happen? If you go by what you are submitting, section subclause 1 and 2 of section 170 will be set to nugatory. Means we nullify it. Because section 170 says what? When can you take defense of owner and driver? On 2 conditions. One, if there is a collusion between the claimant and the owner and the driver. This is one condition. Second, they don't appear and contest the suit or the claim. Now you have to pay. Why should you pay when there is a collusion between the two? Why should you pay when the owner who is supposed to defend and his defense decides has got a monetary implications, and then if he does not, then automatically you say that look, I have to pay, and this man is supposed to defend, he's not defending, or if it's gone proceeded ex parte, then you can. But saying that, making a distinction between you being notified by just because your name is there in the claim petition, does it mean that you have also got the right to contest the matter on merit, and those 2 conditions we don't need to examine? Has the Supreme Court struck down 170 clause 1 and 2? Just by virtue of you being a party in a claim petition, does it necessarily mean by implication that you don't have to establish that there is a collusion? You don't have to establish that parties are not contesting the matter on merit? Automatically, that's what you say, isn't it? Automatically, just because I am a party, till you are just being notified. Even if you file a written statement on merit, we are not going to look at it on merit because you are not a party now. You are not a party now. But 170 application allowed means you are a party. That is what it says.
As of now, I'm only a noticee.
Yes,
That's point I want
because
to clarify,
because you don't have the right to contest the claim on merit. You don't have the right. You are not a necessary party also. The judgment says that you are not a necessary party. You should not be made a party. In a claim petition, you should not be made a party. By the claimant, you should not be made a party. You should be only notified. You are not a necessary party.
Yeah, it also states that, Your Honor. I understand point also raised, but I'm just confused because the Act does not require the claimant to implead the insurer as a party.
That's what I'm saying. We have read this judgment.
What if the claimant choose to implead the insurer as a party, not being a noticee? I'll search some clarification, Your Honor, regarding this because
Okay.
it talks about whether I'll be impleaded party either by the claimant.
Please
or by
try
the
to
court.
understand. Please try to understand the distinction between impleading as a party. Please look at the word
Yes.
meaning, impleading. We have CPC. CPC will be guided by CPC. Read order one. It means impleaded as a party means you are added as a party. Okay? But if you are already a party, where's the question of you being added as a party?
I thought I was in the claim petition. I was added a party respondent in.
Impleading is adding a party in a suit or a claim pending, means adding something. But when things are already there, where's the question of adding? When you're already a party, means you are their party as being notified. If you are not, if you are a regular party, then you can file a written statement on merit. Now it is how can at that stage we can come to the conclusion when we are issuing notice, when we are notifying you at that stage, how can we come to a conclusion that there is a collusion between the owner and the claimant? How can we come to a conclusion that the owner is not contesting the matter on merit at the stage of notice? How is it possible? And that those are the two conditions on which you can contest the matter on merit. The word used there is merit. Impleading means you say that my defense is only statutory defense, only the breach of policy. So I am just a pro forma. But the moment they don't defend or collusion is proof, then you tell the court, look, I have to pay the money, and this man is supposed to defend himself. He's not defending, or there is a collusion between the claimant and the defendant. Now I have to contest the matter on merit. Now I'm implead as a party. Have you got my point?
I got it.
We cannot. It will run to the concept of a civil jurisprudence that a person he is a party to the suit and we don't allow him to contest. Can it be done? Can anybody be deprived of contesting the matter on merit? No, we cannot. But here the law says that you cannot contest the matter on merit because of section 149. You will confine to your terms and conditions of the policy. Only to the extent that you will not be liable to pay compensation, or not be liable to pay compensation if there is a breach of policy. Because my agreement with the owner is to this extent: if the accident takes place under these circumstances, or if there is a breach of policy, I am not liable to pay. It's not question of there is no liability. Liability is there, but I will not take the liability because there is a breach of policy. Owner will pay from his own pocket. Only to that extent is your defense. But you can contest the matter on merit, the age of the person, these multiplier calculations, income, merit, everything. This is supposed to be done by the owner, not by you. But if the owner does not do it, but your argument that just because notice has been issued to you, you get automatically section 177, 170, all the conditions mentioned there, like collusion, not defending. He said that no, we can say go by to everything. We don't need to look into it. Moment I made a party means it will be presumed that there is a collusion or the owner is not defending. That's absurd. That's absurd. That's not the way we read law. And that's not the way we understand. We are aware this 2011 judgment, and it doesn't hold good. Look at the judgment, new judgment has come. This is not there. You don't come with those judgments. And madam, you don't know also application has been filed or not.
We didn't receive any application, Your Honor.
You have not served the copy to them. You mean to say that you put an allegation against the owner and the driver that they are not defending, or they are in collusion, without they having the right to oppose to your application. You'll be automatically allowed and label them to be a person in collusion and a person not defending.
See that I misunderstood the judgment.
Please
But,
read the judgment
I'll
properly.
come, if I find something else, I'll come. But after,
But no, we will otherwise allow.
yes, application I filed.
If your application has been filed, we will allow. The owners are not appearing. The matter is proceeding ex parte. So they are not defending. It's very clear.
Yes.
We'll allow. But you say that automatically. I'm so sorry.
It's because of that
I'm so
judgment
sorry.
only.
Automatically, we cannot say that two grounds mentioned there. These are serious allegations against the owner that they are in collusion or they are not defending. A case might be there. Suppose it turns out to be a case while passing the judgment, you also establish that there is a breach of policy.
Yes.
Then what order will be there? What order will pass?
Against the,
No, will pass an order insurance company to pay and realize the money from the owner.
yeah.
And why are you not settling this claim?
It's because actually permit also it's only for all Assam. We have verified the license also, fake license. We have run the numbers through DTO also. It reflect a different person's name, not the one they submit before the police.
But a fake license, anyway, we'll decide
Yes,
when it comes to the
because
balance.
we have points.
May permit fake license, but the vehicle was insured, isn't it, that time?
It's a
But the policy says that they should apply the vehicle with a valid permit.
permit, yes. Only all Assam only.
Okay. Then what order do you want?
But all the parties are not here yet today.
Then what order? Learning counsel for the claimant, you are appearing?
Hearing of
Serve the copy to them. You want to file any objection, you file. Serve the copy under section 170. We'll look into that. We'll answer that your question.
yes, sir.
But not this way. Yes. Learner counsel for the claimant. You are appearing in item number 1?
Yes, Honor. MSCT case number 1.
Sinchar Kindia.
Sinchar Sharma,
I'm appearing for MSC
Number 1.
number 1. Yes, Honor.
MSCT number 2.
For MSCT number 1, Your Honor, I'm appearing.
We are in the serial number. We don't go by the case number. We go by the manner in which it has been shown in the cause list.
Sinchar Sharma, claimant.
No, we are on the Embalang Suyam.
I'm appearing, Your Honor.
Yes.
MSC.
Yes. What do you want?
Your Honor, I have filed my reply to this application.
What is your reply?
Your Honor, that Section 170 of the MVA Act is
Come to the
required
substance of your reply.
Your Honor, that there's no collusion between me and the owner and the
Right.
driver, Your Honor. That the party or OP number 2 and OP number 3 has been implemented as a party since beginning of the petition, Your Honor.
Yes.
A separate application under 170 Motor Vehicle Act is redundant as the OP number 3 already has full rights to contest the claim and cross the claimant witnesses on the merit of the case.
But they proceeded ex parte against them.
OP number 3, Your Honor.
Who is OP number 3?
Insurance.
I don't get your point.
That the separate application under Section 170 Motor Vehicle Act is redundant as the OP number 3 already has full rights to contest the claim.
We have discussed so much about section 149. You are coming back to same thing. Their defense is limited under section 149 only to the point of breach of policy. Until and unless they become pleaded as a regular party. Once they are pleaded as a regular party, then that means they can cross-examine the witnesses on merit. This is what we are talking about. So what is the objection if they take defense of under 170?
But there's no collusion between me and the owner.
That is one of the ground. Are they saying that there is a collusion? In the application, have they mentioned that there is a collusion between you and the claimant? Don't waste time. Then what for you are making the submission? Is it anybody's case that there is a collusion between you and the claimant? Then
Just filing a reply, Your Honor, on the.
what is your reply? Are you objecting to it?
We
What
are
is the
objecting-
substance of your objection?
We are objecting to the application, Your Honor.
By saying objecting is not enough. Tell us what is the objection? On what ground you are objecting?
Under section 170, Your Honor, including insurer in certain cases.
What is the objection? They want to be impleaded because the owner and the drivers are not defending themselves. Matter has proceeded ex parte against them. So what is your response to that? The objection has to be some lawful objection.
That, Your Honor, they have been impleaded as a party,
Who?
OP number 3, Your Honor. Insurance.
They are party. Madam, why are you not understanding? For almost 10-20 minutes we have been discussing the same thing. They have been impleaded as a party. His argument is that if they are impleaded as a party, they don't need to file an application under section 170. Automatically, by virtue of being impleaded as a party, they get the right to defend on behalf of the owner and the driver, which is not correct. That is what he's been submitting. What is the objection? Are OP number 2 and 3 defending?
Yes, Your Honor, because they have filed a written statement.
So that's enough. That's a proper defense. What is the language used under section 170?
The person against whom the claim is made has failed to contest the claim, but they have written.
Filing written statement is contesting the claim. What happens to the witnesses when they come? You mean to say that just because somebody has filed a written statement, he is contesting the claim? All right. The learned counsel for the claimant present, learned counsel for the OP insurance Siri A and Rimbai present. The insurance company has filed an application under section 170 of the MV Act 1988. The claimant has filed objection to the said application. Peruse the objection. Upon hearing the rival counsel and on perusal of the don't write peruse the objection. Upon hearing the rival counsel and on perusal of the objection filed by the claimant, this court finds that the OP owner and the driver had appeared and filed a written statement. However, they have failed to contest the claim petition. Consequently, the matter proceeded ex parte against the OP owner and driver by which order?
7/2024.
Item number 1.
7/2/2024.
By order dated
7/2/2024.
7/2/2024.
7/2/2024.
Stop. Next paragraph. On cursory reading of section 170 of the MB Act, this court finds that OP Insurance has made out a ground for being impleaded as a regular party in the instant claim petition and contest the claim on merit. Prayer of the OP Insurance to be impleaded as a regular party and contest the claim petition is allowed. Petition number so and so stands allowed and disposed of. Yes, next. Here also, same application, same application, same order, same date of ex parte, petition allowed. This number 3, same, same order, same order. No.
No, no.
Number 2, number 3 is who? You are appearing.
Yes, Your Honor.
Application file.
We just received the copy today, Your Honor.
All right. We don't want to hear you on that. We allow the application. Same order ex parte.
Yes, Your Honor. Yes, Your Honor.
Yes, allowed. Substitution. This 170 application file.
Yes.
Allowed. Same order. Then number 4.
For other
Hadoop high.
cases from clearer.
Here also your file. OP owner is absent. Anyway, we will not pass any order. The learned counsel for the claimant is absent without any steps. They file steps, right? The impleading application of the OP insurance shall be taken up on the next date fixed. We'll see that next date. All the matters, no? The other matters are there. But that is a very 2011 judgment. We have read it long back. It says that the insurance company is not should not be made a party also. They are there only to pay the money. But to reading that, please try to understand the word meaning impleaded, notified. We are in a legal proceedings. We are not in some literature class. How does the law look at these words when we say impleading, when we say notified? Notified means how can you be notified? Tell me.
Right into section 149, according to that.
How you be notified?
Notice only. We
How
are not
notified?
necessarily. We are not.
If you want to be so, if you want to be so technical, relying on 2011 judgment, then we also will be very technical. Second part, where is your nodal officer?
Nodal officer.
Yes. What happened to the mediation in this case? Was mediation carried out? Read 49 properly, clause 2. Anyway, you read for yourself. We can't have a claim petitions without the remedy of mediations being exhausted. That is one of the precondition. It is just like you do civil cases. It's just like section 12A of the Commercial Court Act. You without pre-litigation mediation, you cannot file a civil suit. Hmm. ठीक है.
Good day.
Yes, divorce case क्या है? Yes. Yes. Who's the parent?
This
Yes.
divorce petition number 3, Madam Your Honor.
Yes.
We filed this mutual divorce application. It's we filed under particular situation, my Your Honor, and what happened is, Your Honor.
All divorce are peculiar situation only.
Yes.
All divorce applications are peculiar situation. Yes. Yes. What do you want? What do you want now?
Yes.
No, we don't want to know what happened in the bedroom.
We have filed this for.
No. What do you want now? What do you want now? We are at the notice stage.
We have come with this on report, praying for a mutual divorce.
All right. Then what? We'll issue notice. We have to fix the matter for their appearance. We have to fix the matter today for their appearance. Without exhausting the reconciliation, we cannot pass any order. Where are these parties?
Here. Here.
Where are the parties?
Parties are parties. Your Honor, we can make them appear, Your Honor, if you insist.
All right, we get through VC.
Be very possible, Your Honor. Your Honor may fix up tomorrow, day after, any day, Your Honor. We can make them appear.
We'll fix next year. Fix after 6 months. We'll fix after 6 months. We'll fix the matter after 6 months.
Your Honor, for exemptions for that, we will allow to file the application for exemption.
Sorry?
Putting up the Your Honor. Your Honor, may kindly allow us to file that, allow us to file an application seeking exemption of the putting of the.
File.
Participating persons, they are ready to appear, Your Honor.
File. We'll see. We'll hear and we'll examine it.
From our side. We'll do that. Your Honor. Kindly allow us.
Learned counsel for the claimant, learned counsel for the petitioner appear through VC from Shillong. And sought for time for filing appropriate application to condone the cooling off period of 6 months. Pray aloud. If any such application is filed, the same shall be considered in accordance with law. Fix after 6 months.
For the witness, Your Honor.
Fix this matter after. Fix this matter after 6 months. This matter shall come up after 6 months of the cooling off period. On the date fixed, the party shall appear. Yes. Next. Yes. Yes. This matter after 6 months. Yes.
Putting ông smile. Vâng, ông hẹn. Smile. Làm gì không? Vì học lần hết. Apply. Yarap ini. Tiếp phang này case mà. Oh, chap kem kong. I know of the instant case as the accused is my brother-in-law. Kamu tarik upnai Muslim. Ya tarik dok hande tarik upnai June aja so to. The agak tarik you aja nama. Karena mangkamu tipis panggani ni dah saya kot.
Ngau koi kulit yung
I know yung bay mo.
hayong kan yak ngam di le yu tib dur wan ni perkat ngam tib yes ya tay lai lang kulit te
On the 9 June 2024, Istam mo ay jan no point police. On morning time, the police came to my residence. I know iti yung kan came to my residence and Nyok my village and asked me to accompany them to search for the accused person. See one hypercut na to. Adam nito ba? Em mo pa sang kot ki pulit pe to.
em hai tang tib re yi tau san yi sa
Thầy dụ go kem em kan to. Apa nam kan to no. Teman lagi hanu kem yo. And then we left. Thereafter we left my residence. Dekat negeri pulit. My resident, along with the police in their vehicle. And on reaching Lat Mochrat, mana point Lat Mochrat kamu liu jo.
ki so yo nang tok mo tai mo tok ai sa
On reaching Lat Mochrat, the police saw the accused person. The police see the accused person and ask me whether he is the one. And I tell them, yes, he is one hypercut latong. And I replied, I told them, yes, it is one hypercut latong. And the police arrested the accused person. Mandap okem nito. Kaya ang hasan nito.
san yi nang san ni ni
Mandap yo sendu ya go sa. When the police arrested the accused person, I was asked to sign on one paper. And I don't know what is the purpose of me signing the paper. And I don't see the police seize the material seize material from the accused person. The item under that keep pull it up. Kita nu pen here. Song kita pull it. And there the police left thereafter the police left Lat Mutrat, and I don't know where they take the accused person. And there I proceed to my residence, and from there I proceed to my residence. Well, when you have to agree to court of sign you pull it. The witness identify the same and mark herein as exhibit 5, and exhibit 5/1 is my signature. Your Honor, he don't see the seizure, he don't see anything, he just made to sign paper. Is it necessary to show him the seized material?
Yes.
With permission of the court then?
Yes.
Open your many clear for him. Let me down. CMR 54 2024 slash 54 slash 2024. Open your man. Baik kan ni kita rito, ini kita yang ni kan tadi. On being shown, material exhibit 1, Cassie knife. Material exhibit 1, Cassie knife with a wooden handle. The witness cannot identify the same as do not see the material when it was seized. And on being shown material exhibit 2, Cassie sling bag, brown with white and red stripe. With white and red stripe. Cầm trộn. Aging to kia sa em sổ phẩm. That's all.
Tay cái pulit if no he thought to show sign be. It is a fact it is a fact the police never explained to me the content of exhibit 5. Police did not explain to me the content of exhibit 5 before I put my signature.
Yeah. Yes, yes. No, no, sir, very short. I can do it. Yes. Yes, please tell her.
Yes,
Yes.
on the 10/6/2013, an FIR was lodged against Dengki Situng and Bibi Situng by the President and
10/6.
10/6/2013
Who filed the FIR?
by the President and Secretary VDP Barato A. Against the accused person, Dengki Situng and Bibi Situng. As per the FIR, Your Honor, it is in Khasi.
Yeah, please read.
Ngi kum kiseng VDP Barato A ngi wan bu persya yakane kerepon Ahmad Jongpi berpen sengobha ban kem ya kita kibriu aneng bahakamit kendai trikship ru arjap hale hakapor khatway beci menmet kila penyap dusman ya UNT Jadak Barato.
Yes.
And on the 14/4/2014, the charge sheet was filed against Dengki Situng and Bibi 14/4/2014 against the accused Dengki and Bibi on the section 30234.
Who are the accused? Accused against accused?
Dengki Situng, Samati Dengki Situng, and Shri Bibi Situng on the section 302/34 IPC.
Yes. Please find out the committal order. Yes.
Your Honor, the prosecution has, and the charge was framed against the accused Dengki Situng on the 21st January 2019 on the section 30234 IPC, where the accused pleaded not guilty and claimed for trial.
Yes.
Your Honor, the prosecution has examined 9 witnesses to prove their case, Your Honor. Your Honor, from the
1 second. Who is witness number 9? Yeah, only 8.
IOCI C Lamare.
PW9.
Second IO.
Yes. Yes.
Your Honor, from the evidence on record, PW1, PW2, and all the witnesses, Your Honor, there is no evidence made against Dengki Situng except from the
Who is
evidence.
PW number 1?
Your Honor, he is the secretary of VDP, Darling Thakar, who lodged the FIR, Your Honor.
Yes. Yes.
And PW2 is the president. He also who signed in the FIR.
He's secretary of what? PW1?
VDP, Barato A.
PW2?
He's also president of VDP, Barato A. And PW3 is the headman of Barato A.
Yes.
Your Honor, from his evidence, he stated that on receiving the information, I was informed that Shri NT Jadak, the husband of
Whose evidence you are reading?
PW3, Your Honor.
Why not PW1?
So there is no evidence against the accused Dengki Situng. He stated that On that morning, some villager came and informed me that there is a dead body in the house of the accused Jaintia Situng. On learning about the incident, I gathered the VDP members and went to the house of the accused Jaintia Situng. On reaching the house of
Okay,
Jaintia,
evidence of PW2.
yes, PW3, he stated
Two,
that
two, two.
on the day of the incident, I received a telephonic call from Bright Star Shadab informing me that it seems there was a murder in the house of the accused person, Samati Jaintia Situng. On learning about the incident, I gathered the members of the VDP and after some time went to the house of the accused person, Jaintia Situng. On reaching the PO, we saw the dead body of the husband of the accused person, whom we used to call Naga. Then we informed the police at Naktiang. But the police asked us to bring the accused person, Jaintia Situng, and her son, whom we used to call Bibi Situng. Then later, we managed to put the accused person, Jaintia Situng, and her son, Bibi Situng, in a gypsy vehicle of their uncle. But on reaching halfway, the accused person, Bibi Situng, jumped from the vehicle and managed to flee away. So we have taken only the accused person, Jaintia Situng, to Nartiang Outpost.
Where is the BB stream?
Oh, it's declared absconder.
Huh?
Declared absconder.
Which order?
Not check the order, but prior to my appointment as LAC, he has been declared absconder.
Order?
I have not checked the order.
Check when was this accused BB stream declared absconded. Yes. Yes.
Also, PW3, he stated that when the incident happened, I was informed by some
PW3 is headman.
He is the headman. Some
Yes.
villagers at around 7 a.m., I cannot remember the date, month, and year of the incident. I was informed that NT Jadap, the husband of Jaintia Situng, was murdered. On knowing, I, along with the secretary, VDP Barato A, rushed to the house of Samati Jaintia Situng at Barato village. When we reached the house, we opened the door and saw Samati Jaintia Situng in the kitchen and her deceased husband in the bedroom, but we did not touch the body. On asking Jaintia Situng, she confessed that she had murdered her husband. We also saw the firewood along the dao used in committing the crime, and the same were lying beside the dead body of Sri Anti Jadap. Therefore, thereafter, Sri Darling Thakar, secretary of the VDP, informed the matter to the police at Nartiang PIC. Later, the police came to the house of the accused Jaintia Situng and took the dead body. The police also has seized a murder weapon, that is one firewood and one khasi dao, in my presence. Now, Your Honor, it was only PW3 who stated that on asking Samati Jaintia Situng, she confessed that she had murdered her husband. But Your Honor, the secretary who was with PW3, PW1, he never stated that the accused had confessed to the commission of murder her husband, Your Honor. It was only PW3 who stated so. Even the president did not state that the accused had confessed to them that she had murdered her husband, Your Honor. PW4, Your Honor, who is the sister of the accused person, sister of Jaintia Situng. She informed that I know about the incident as the accused Jaintia Situng, who is also my sister, came to my house at around 6 a.m. informing me that there was a fight between Bibi Situng and Enti Jadab, as a result of which Enti Jadab died in the house of the accused Denti Situng. Thereafter, I, along with the accused Denti Situng, proceeded to the house of the headman, Barato, to inform him about the incident. Your Honor, the PW3 is silent about this part, that it was Denti Situng and PW4 who went to his house and informed about the matter to him, Your Honor. Your Honor, the accused person, Denti Situng, had also made a confessional before the magistrate PW7. Your Honor, in her confessional statement, she had never admitted of the commission of the crime by her, Your Honor. PW7.
Magistrate,
Yes, Your Honor.
read the confession statement.
In her statement, she mentioned that I beg to state that on the
It is
night.
exhibit?
Yes, Your Honor.
Exhibit?
Exhibit 4. I beg to state that on the night of 9/6/2013, my husband came back home drunk, and we sat together along with my son Bibi Situng to chat for a while. While we were having our conversation, my husband Enti Shadab suddenly got angry, and he started arguing violently with us, to the point that it has become a heated argument. After all this, I got up and get dinner ready for my 3 other children. While I was about to serve dinner, my husband got up and took out a knife and threatened to kill me. This is the second time that he had threatened to do so. After this threat, I went outside the house. After some time, I heard my son and my husband started fighting, and when I got back inside the house, I saw my husband lying dead after he was beaten with a stick used for fencing the garden on the head. After the incident, my son left the house, and I have never seen him since.
Whose statement is this?
So this is a statement, confessional before the magistrate.
And this CA Marak,
This is the IO, Your Honor. First IO.
why he recorded the statement? On oath?
This is the first IO, Your Honor.
When was this case committed? 23/7/2015. What happened? Declare absconder? Hmm? 2011/2017. Airports order? 2011. What it says? Yes, yes, Karen. Yes.
You know, from the statement of PW8, who was the first IO of the case, he agreed, Your Honor, that the accused person should be a prime witness rather than an accused person, Your Honor. In PW9, Your Honor, he clearly stated in his cross, Your Honor, that he find no evidence against the accused Denti Situng,
Yes,
and he filed
okay.
charge sheet against
Okay. Yes, yes, prosecution.
Yes, Your Honor. In this instant case, Your Honor, the prosecution is fell short with the witness, Your Honor. As there's no corroborating to that of that PW3, Your Honor, who claimed that the accused person has made an extrajudicial confession. But no other witness corroborate to what PW3 has stated, Your Honor. And plus, Your Honor, there is no other witness, Your Honor, came forward, Your Honor, in order to strengthen the case against the accused person. Therefore, Your Honor, as rightly said by the learned defense, Your Honor, that the prosecution is short of witness, Your Honor, to prove the case against the
learned counsel, learned prosecutor, Sri Sonso, or learned defense counsel, Srimati Sonso. This court had been informed that the accused dentist is bedridden. As such, she could not appear before this court today. The facts which has led to the commencement of the criminal proceeding is briefly facts are briefly recaptured. The secretary and the president of the BDP filed an FIR. Why it is a whitener in the FIR? Bring my dictionary. I filed an FIR before the IC in Artian. PIC, West Jaintia Hill District, Joy. In the FIR. In the FIR, accused in the FIR. Why there is overwriting in the FIR? We have the copy of FIR?
Yes, sir.
We have the copy of FIR?
Because it's zero, so it
It's zero
doesn't.
What is there on the first part? On the heading?
Katkum kate kasab.
No, below FIR. Panshisha. Prasha. Just below Prasha, what is there?
The name of the accused.
Name of the accused, whose name?
So the first one is Denki Situng and the second is Bibi Situng.
Now, who has tempered this FIR?
But for Denki Situng, it's not very visible, not clear.
Was that an FIR? File FIR. Alleging that on 9/6/2013 at 11 p.m. was it Ubrio Haneng? What is that? The Brio Haneng?
Denki Briu Haneng,
Bala?
Baha Kamet, Kandai Rio Athajar Hatnai Hakaposh Hadwe Baje,
Ini. Khatwe Ketuai
11
PM Paul. Mien. La.
Kila penyap dusman yau anti jadab barato.
Alright. Alleging that. Alleging that on the night of 9/6/2023 at around 11 p.m.
2013, Your Honor.
Huh?
2013.
2013 at around 11 p.m. The accused BB Situng, Denti Situng and BB Situng had killed Anti Jadov of Barato. It is very disturbing to notice that there is obliteration in the FIR with regard to the name of the accused Denti Situng. White flute has been used for obliterations. This court shall deal with it in the later part of the judgment. The FIR was registered as the FIR was received at Joy PS White GDE number 197 dated 11/6/2013 at around 9 p.m. and it was registered as Joy PS case number 98 bracket 13 under section 302 IPC. The case was endorsed to C.K. Marak. The case was endorsed to SI C.K. Marak for investigation. During the course of investigation, one firewood and one Hasida was seized. Post-mortem was conducted. Post-mortem examination was conducted over the body of the deceased. Statement of the accused, Denti Situng, was recorded. Confession statement of the accused, Denti Situng, was recorded under section 164 before the magistrate. The IO recorded the statement of the witnesses under section 161. The investigation concluded. Where is the charge sheet? The investigation concluded in a charge sheet number 49/14 dated 14/4/2014 under section 302/34 IPC against the accused Denti Situng and BB Situng. The accused BB Situng was shown as absconder in the charge sheet. This case was committed to this court by committal order dated 22/11/2017. charge was framed against the accused person. No, 2017. Yeah. No, don't write, don't write. Only charge committed only. The committal court. Before that, no? Before this charge is committed, no? Before this case was committed, before this case was committed. The committal court. By order that the committal court had issued. The committal court had issued. Give me the water. The committal court had issued a notice of proclamation and attachment against BB Situ after being satisfied that it was executed in accordance with law. Comma, declared the accused BB Situng absconder by the order dated 20/11/2017 and further directed that the matter shall proceed against the accused Jaintia Situng. This was committed. Charge was framed against the accused Jaintia Situng on 21st January 2019 under section 302/34 IPC. The accused pleaded not guilty and demanded trial. During the course of trial, the prosecution examined 9 PWs, exhibited four documents. The victim, the accused could not be examined under 313 as she was bedridden, as she is bedridden and not in a position to depose, or not in a position to be examined. Medically not in a position to be examined. Nevertheless, the defense was given an opportunity to bring defense witnesses. They declined. It was declined. Prosecution declined. As such, the matter has come up for final argument. Prosecution, a learned additional prosecutor, Sri So-and-so, prosecution case, fairly submits that the evidence which has come during the course of trial does not establish or connect the accused with the offence charge. Prosecutor regrets that the prosecution case has fallen short To establish the case. Not full stop. Fall in short to establish the case beyond reasonable doubt. As such, and then the prosecutor submits that its court may pass necessary order after examining the material on record. Learned defense counsel, legal counsel submit that the prosecution, which evidence is there? He confessed.
PW3 on.
Prosecutor submit that. Submit that the prosecution. Defense counsel submits that the prosecution has failed to bring any evidence to connect the accused with the crime. The prosecution evidence which is unfolded during trial revealed that prosecution has miserably failed to establish the charge. The defense prays for acquittal of the accused of the offence charge. Decisions and the reason. The defense and the prosecution appears to be on the same page that no case has been made out for the conviction of the accused for the offence charge. Cases has to be decided not on the basis of the submission made by the counsel, but on the basis of material available on record in the form of evidence. As such, evidence. Full stop. This court undertakes the exercise of evaluating the evidence of 9 PWs which is unfolded during trial for the purpose of determining the charges. PW1 and PW2 are the informants. They had triggered the investigation by filing an FIR. PW1 was the then secretary of VDP, Baruto A. PW2 was then the president of VDP, Baruto A. On perusal of the evidence of PW1 and 2, it emerges that both were informed about the death. Both were informed about the dead body found in the house of the accused Jaintia Situ. On learning about the incident, they went to the house of Jaintia Situ. And saw the body of NT Jadop, NT Jadop. From the evidence of PW2, it emerges that PW2, it emerges that the deceased NT Jadop was known by a pet name Naga. The police had asked to bring Jaintia Situng and her son Bibi Situng to the police station in a gypsy. While they were on the way, the accused Bibi Situng managed to escape by jumping from the gypsy. As such, he would not be taken to the police station. Stop. PW1 and 2, as stated in the FIR, that NT Jadop, na?
Jadab,
Yes, sir.
DOP.
NT Jadop was murdered by Jaintia Situng and Bibi Situng on the night of 9/6/2013. However, before this court, both the informants are silent with regard to the involvement of the accused persons. Both the PW1 and 2 has not made even a whisper with regard to the murder of NT Jadov, which only manifests that the facts stated in the FIR has not been established by the informants. Further, there is interpolation. Further, there is obliteration in the FIR with regard to the name of Jaintia Situng, which makes the prosecution case very vulnerable. A white fluid has been used in the FIR. The IO is answerable to the same. Full stop. The evidence of PW3, headman of Barato A, revealed that he went to the house of Demti Situ after learning about the incident and found the accused Denti Situ was in the kitchen and the body of her husband was lying in the bedroom. The accused Denti Situ confessed before PW3 that she killed her husband, Entry Jadhav. In other words, then full stop. In other words, comma, the accused had made an extrajudicial confession before PW3. It is a settled law that the extrajudicial confession is a very weak piece of evidence unless supported by cogent evidence. It will not be safe to rely on extrajudicial confession statement. This court is not totally discarding the extrajudicial confession made by the accused Denti Situ. Other evidence shall be examined to find corroboration to the extrajudicial confession. The evidence of PW4 goes against the prosecution case. The witness PW4 reveals that the accused Denti Situ, along with PW4 bracket sister, went to report the matter to PW3. That there was a fight between BB Situ and NT Jadhav, and in the said fight, NT Jadhav died inside the house of Denti Situ. The evidence of PW5 is of not much value. The evidence of the Dr. PW6 establishes that post-mortem examination was conducted on the body of NT Jadhav at Civil Hospital, Joy, after conducting the autopsy, PW6 prepared a post-mortem examination report, Exhibit 3. The doctor PW6 intracranial hemorrhage caused by a blow with a hard blunt object, and the injury was antemortem. The postmortem report, Exhibit 3, and the evidence of the Dr. PW6 clearly establishes that the death of NT Jadov was a homicide. In a trial of a murder case, it is not enough to establish only death. A person who is involved in causing death has to be connected with the death with the lawful evidence. Which this court is scrutinizing. It appears from the prosecution case that PW7 had made a confession statement before PW7, and the confessional statement has been exhibited as exhibit 4. It appears that the magistrate and the investigating officer did not have any clue of a distinction between confession statement of an accused and a statement of a witness under section 164. Full stop. A colon. The testimony to this fact is that the testimony to this fact is the confession, the purported confession statement of the accused. Exhibit 4. Full stop. The accused stated before PW7, quote, I beg to state that on the night of 9/6/2013, my husband came back home drunk, and we had together along with my son Billy, what's his name? BB shooting. It is what had over. Huh?
We sat together.
Oh, sat together along with my son BB Stoom for a while. While we were having our conversation, my husband, NT Jarab, suddenly got angry and he started arguing violently with us to the point that it became a heated argument. After all this, I got up and got dinner ready for my 3 other children. While I was about to leave, my husband got up and took out a knife and threatened to kill me. Full stop. This is the second time that he has threatened to do so. Full stop. After this threat, I went outside the house. After some time, house full stop. After some time, I heard my son and husband started fighting. When I got, what is that? When I got?
When I got back inside the house,
When I got back inside the house, I saw my husband lying dead after he was beaten with a stick used for fencing the garden, on the head. Full stop. After the incident, my son left the house and I have never seen him again. And then I have never seen him since. Full stop. This is a statement. The prosecution claims to be a confession statement. It will not be necessary for us to educate on confession statement. Full stop. Any admission to a crime, any voluntary admission to a crime is a confession statement. The above relied by the prosecution strongly goes against the prosecution. It is a piece of evidence which has been brought during trial. This court cannot ignore it. From the statement of the accused, it emerges that the prime accused in the instant case is Bibi Situng, son of the Denti Situng. On reading the evidence of PW3 before whom extrajudicial confession was made by the accused? Juxtapose the evidence of PW 7 and 5. PW 5, whose sister is PW? Sister? PW 4, not 5, PW 4. Juxtapose, JUXTAPOSE. Juxtapose the evidence of PW 4, PW 7, and Exhibit 4. This court finds it will not be proper to solely rely on the extrajudicial confession statement of the accused without corroboration. The prosecution evidence strongly contradicts with the evidence of PW3. First off, this court has perused the evidence of the IO. Where do you say that? Which IO?
First IO.
PW8.
PW8.
Where the IO candidly stated that there is no evidence was found against the accused Jaintia shooting.
And PW9 also.
Similarly, PW9 has also echoed the same voice of no evidence against the accused Jaintia shooting. Conviction, Mustafa, cannot be on assumption and presumption. No, conviction cannot be solely on assumption and presumption. Prosecution, in order to succeed in a criminal trial, has to establish beyond reasonable doubt that the accused has committed the offence charged. In the case in hand, the prosecution evidence itself reveals that the accused, Jaintia Shooting, was not the perpetrator. She was made to stand for trial. For 6 years, only to be acquitted. How many more cases of this nature are pending? Crying the call for justice. No, not how many. There are many more cases, sorry. There are many more cases of this nature pending, crying for the call for justice. a flawed investigation, or a malicious investigation is threat to the system of the criminal justice system. Is a threat to the criminal justice system. Unless innocents are not protected and guilt are punished, people will lose faith in the criminal justice system. Prosecution has miserably failed to establish the charge of murder under Section 302 IPC. Consequently, the accused Jaintia is acquitted of the charge under Section 302 and set at liberty unless wanted in some other case. Next para. The bail bond of the accused Jaintia shall stand discharged without any further order after the expiry of statutory period of appeal. The Ayog is directed to destroy the material exhibits and file a compliance. Case stands disposed of on merit. Yes. Anything else? C13 will not do. Will not do C13. Anything?
Verification for the Mandahari.
And we are coming from Cleria.
Yes, Your Honor.
Okay, we'll take tomorrow. We'll call for the records.
Yes, sir.
Huh?
Because it was handled by S. Chamson, Your Honor.
Tomorrow can we take?
Yes, Your Honor.
Tomorrow.
Yes, sir.
Okay, we'll take up this bill.
I oblige, Your Honor.
Anything else we have?
Nothing.